Hello and welcome to L2 Construction Series. Good afternoon, everyone. My name is Hong Kit and I'm your host today. Before we start today's session, I would like to thank Dr. Naseem for spending his precious time over these 5 days to share some extremely useful information and knowledge with us. It is always easy to come to a webinar and bore everyone with some monotone script reading performance. But believe me, it is definitely no easy task to prepare a live webinar like Dr. Naseem does. Interesting, entertaining, and full of passion. Not to mention, he has been doing this since Monday. I'm sure the audience has greatly benefited from these sessions. For those who either missed the earlier sessions or would like to watch them again, they will be uploaded to L2 Construction Series YouTube and LinkedIn. You can follow us there to receive future updates. Do let us know your feedback so we can continue to bring you more interesting and informative webinars. Without further ado, I will now present a certificate of appreciation to Dr. Naseem. Thank you for helping us become more aware of plain language construction contracts and also the ways we can apply plain language. Okay, Dr. Naseem, please come on up here to receive this certificate. Over to you.
Right.
Are you there? Yes.
Yes, I am. Thank you very much. Can you hear me?
Yeah, I can.
All nice and clear?
Yes.
Okay, I will start sharing screen first. Once the Daniel, tech moderator. Hey, maybe Daniel can show himself if he's properly dressed, that is. Because some of them might not have seen Daniel, our tech moderator. So it'd be nice to see Superman. Maybe not now, maybe later. Ah, there you go. That is tech moderator Superman without his glasses.
Hi, everyone. Nice meeting you all.
Okay, let me share the screen now and we'll start. Okay, can I proceed?
Yes, please, Dr. Naseem.
Okay,
over
right.
to you. The stage is yours.
Okay, good morning, or afternoon, or evening, everyone. As over the past 5 days, we've been doing this, so it's the same routine again. Remember, safety is paramount. So after the greetings, we must have a briefing on the health and safety house rules for emergencies. And don't forget to bring your emergency kits, right? So in my case, my emergency exit is straight out through the door, grab the kids and the wife and everyone and say, let's go. And we go down the stairs, out through the front door, down the shared driveway, not forgetting to bring our Whittaker's chocolate, if I can find it. Anyway, it's there somewhere in the bag. So that's for emergencies, if there is an emergency, wherever it is that you are. And we're in a COVID-19 situation, the drills are the face, don't touch your eyes, don't touch your nose, don't touch your mouth, clean hands all the time throughout the day, and physical distancing, not social distancing. There you go, that's a drill. Now, over the past, today is the 5th day, we've been looking at forming stage of construction contracts. We looked at performing. We looked at the time clauses. We looked at the payment clauses. We looked at the termination and subcontracting and quality clauses. Today, we'll be looking at 3 aspects. Storming, which is the dispute resolution elements. Reforming, some ideas for reforms. And norming. What happens not post-COVID, but post-2030, when all construction contracts are written in plain language. Right. So on day 1, that's what we did. Yeah, contract formation, plain language drafting principles. We looked at contract administration using pro forma and the making of the contract, the plain language contract, which I've used as to demonstrate a lot of the points. The 2nd day, we looked at the time clauses. 3rd day, we looked at financial issues. And yesterday, we looked at some quality issues and subcontracting, termination, and so on. And today, we'll be looking, as I said, dispute resolution, some reforms, plain language drafting. We've already done that, but I'll keep emphasizing that very quickly on smart contracts. And then we'll look at continuing education. Some of you have asked some questions related to it. And don't forget, from yesterday's questions, I will also be responding to all the questions that you asked me yesterday. I feel that I enjoy that more because rather than me standing or sitting here and just yapping away. I would rather deal with your questions. What is it that you want? So that's why I spend a little bit of time dealing with your questions, and they cover all aspects anyway, but I'll deal with the questions from yesterday. Now, I mentioned storming. I will be dealing with storming. Disputes are everywhere. When I want to walk in Kauai Island, in Auckland, not far from our house, maybe about 40 minutes drive or whatever, and across onto a boat to an island, what do I see? Dispute Cove. So disputes are everywhere. As a reminder, the overall vision of all this, the idea of this is, and to demonstrate it, we've been using lots of contract clauses and so on. The vision is this, Vision 2030, my Vision 2030 is this. All construction contracts in the world, whether they're smart or the normal contracts, has got a proper structure and plain language drafting style that parties to the contract, the client, contractor, subcontractor, supplier, the contract administrator, architect, engineer, QS, and dispute resolvers like lawyers, arbitrators, adjudicators, and mediators can understand easily. The standard was, the British standard is generally on first reading. I would suggest, as long as we can understand it on second reading, that's fine. And how to do that? A white paper, which is coming up, and I've got a set of modern drafting guidelines, which will be included within the white paper. Now, one of you asked a question yesterday about, I would, really like to be able to draft contracts in plain language and all that. How do I do it step by step? Now, I don't know how to sort of spend just 1 minute or so explaining how to do it step by step. All I would say is this. You will be surprised that when you first start, if you're used to the traditional style, you'll pick up a piece of paper and start saying, whereas, and then you put the background, the parties hereby agree as follows. But the more practice you get, the better you become. And now, for instance, I don't do that and then translate it to plain language. I just do it straight away. I just go background, give the background, and then terms of the contract, and then you just get straight into it. So I think the answer is practice, and you can do that. There are lots of books and so on which shows you how to practice. Now, I want to also share one or two things because I want to acknowledge our sponsors, CIDB, CIB, and RISM, as well as, of course, L2. I want to do this right up front. L2 have been absolutely magnanimous and really altruistic, looking at society's interest before self-interest by coming up with a series. They don't have to have done it. They did it for 30 days, some sessions morning and afternoon. Now that's a true commitment, very professional. That is, so I want to thank Lam Wai Lun and Yang Hong Kit for that. Now, in the same way, people like CIDB and RISM and so on have contributed a lot to the industry, and master builders as well. They've contributed a lot. But sometimes people just take them for granted. I just want to say that CIDB has done its part. For instance, when it came out with the master plan, this going back many years ago, they said, oh, the Malaysian construction industry is to be world-class by 2015. So you can imagine how many years ago they had that vision, if you want, or master plan. And amongst that was 10 working groups, and working group 10, which I chaired, is called WG10 on payment. Amongst the things that we did, again, CIDB is the one who was very supportive of it. We went to the UK. We looked at adjudication models around the world. There are 14 now. At that time, there were fewer than that. And we looked at the Australian one, we looked at the New Zealand one, the Singapore one, and of course, the UK one, and the various Australian ones, not too many at that time, not all of it at least anyway. And one of the things we did was, we were inclined towards the New Zealand and the UK Act rather than the Australian Singaporean Act. And when we went to the UK, this picture shows pretty much the who is who in the UK. Rudy Klein, and I mean, these are some of the top world authorities, of course, including Professor Philip Kapper and John Riches and so on. Now, the four of us who went from Malaysia was myself, Puan Saria, Yang Arif Lim Chong Fong now, as he was then, Surveyor Lim Chong Fong, and Jeff Bailey. Jeff Bailey is actually from New Zealand. And he was instrumental in sort of mooting the idea in New Zealand many, many years ago, early 2000s. And he decided to join us as well. because he thought he could also contribute. And that's what we did. And what then happened was we looked at the various acts. And one of the things we found was this, for instance, comes from the Singapore Act. Nothing in subsection 1 shall prevent the claimant from including in a payment claim in which the respondent's name and amount that was the subject of the previous. This is what QSs, architects, engineers, clients, developers, contractors, subcontractors are supposed to read from the Act and understand it and act on it. I have asked this question on the 1st and 2nd of April 2009 in front of 160 parliamentary drafting councillors. That means they are the ones who draft acts of parliament from around the world. 160 of them, mainly from Commonwealth jurisdictions, but there were some from America, Canada, and so on as well. And I asked them, you guys drafted this. This comes from the Singapore Act. I said, you drafted it. Can someone please explain to me, I'm only a QS, what this means? There was a stunned silence. They couldn't explain to me. I presented a paper from a user's perspective. They couldn't explain to me. And they kept running to me. And in fact, one of the Australians put up his hands and he said, well, this is exactly why we appreciate people like you coming and giving us feedback. I appreciate that. But when it came to the tea break session, 3 chaps came running up to me and saying, oh, Naseem, you know, well, in Singapore, you know, that's how we normally draft. I said, yeah, I know. You shouldn't do that anymore. You should try to adopt. And that's why we're here, to learn different style methods like this. A payment claim must be in writing, must state a claimed amount, must state the due date. This is a style. That's why you're here at the conference. It's a year, I know, but our bosses, you know, that's how they draft lah. I said, then your bosses should be here. Well, you know what happens, right? When the bosses come for conferences, what do? They play golf. Anyway, that's the way it is. That's life, okay? And this is another example. Payment claim must be in writing and all that. I mean, this is nice and simple. And here's another example, which comes from the New Zealand one. It says here, on section 25, it says here, subsection 3 prevails over subsection 1. Brilliant. Not subject always to subsection 3, 2, 1, or whatever. No such thing. Nice and simple. Brilliant. And I actually, in 2009, I posed a challenge to the Commonwealth Social and Legislative Council and the Parliamentary Council Office. I said, why don't you guys develop a single set of standardized legislative drafting guidelines? We can Google today and find the New Zealand one, sections of it. We can find the New South Wales one. I found the relatively new Hong Kong one, which were all brilliant. So why don't you guys come up with a consistent one, which is in plain language? Well, it's hard work, but anyway. Now, the other thing I want to mention very quickly is this. This is the purpose of the Act in Malaysia, which eventually had CIPA, Construction Industry Payment and Adjudication Act. This is the purpose: an act to facilitate regular and timely payment, provide mechanism for speedy dispute resolution through adjudication, and provide security and remedies for the recovery of payment in the construction industry. And look at this. The New Zealand Act says, the purpose of this act is to reform the law and in particular, facilitate regular and timely payment, provide speedy resolution, provide remedies. Does this look familiar? Well, I tell you why it's familiar. This is the Malaysian one. This is the New Zealand one. When I was chair, 15. I actually thought amongst all the acts in the world, the New Zealand one was the best. Chong Fong agreed with me, Young Arif now. He said, yeah. So the model that was drafted as a draft, which CIDB commissioned Young Arif, Lim Chong Fong, then as a lawyer, to draft, we followed exactly the New Zealand one, except that the final version of it is not as laid out. You know, can you see A, B, C? Brilliant. This is similar message, but this is presented better. Everything counts. Now, anyway, so when I chaired that working group on payment, WG10, Chong Fong being the other member, the first 5 years started in 2003. What happened is there was a round table coordinated by CIDB. The whole industry got together, like the Malaysian Latham, if you want. And 10 areas of priorities were identified. WG10 I already mentioned. In the following year, pretty much same month in June, WG10 made recommendations for some sort of an act governing adjudication. And earlier we called it Construction Contracts Act. as just a name anyway. And people got confused. They thought, oh, you're going to force us to use the CIDB contract. Oh my goodness, not at all. It's about payment and adjudication. So the Act's name was born in 2004, where I thought, what is the Act about? It's about construction industry payment. So why shouldn't the name construction industry payment be in the Act? It should. And what else is the Act about? It's about adjudication. Of all the 14 jurisdictions around the world, the Act with the best name in the world is the Malaysian one. It's called Construction Industry Payment and Adjudication Act. Brilliant. That's the best thing in the Malaysian Act. Now, and then there was a national forum, lots of people attended. And then the following year, we had an international forum. We got Jeff Bailey, we got people from Australia, we got, what's his name, Dr. Robert Gaitskell and so on, Humphrey Lloyd, who is a TCC construction judge in the UK and so on. A whole bunch of people came and we had that. And the minister was really excited. And he said, next year we must have a Construction Industry Payment and Adjudication Act. This is what he actually said. He actually announced it to the press. The steering committee was formed and all that. I even had a dummy to show him and he was delighted. Yeah. He was really keen to push it very, very fast. That was 2005, moving on to 2006. We had lots of consultative sessions. We had that trip to the UK and so on. And fifth year, a first draft bill by industry. That's the one I said. Lim Chong Fong, Yang Arif drafted that announcement by the construction industry master plan by the Deputy Prime Minister saying, oh, Malaysian construction industry will be world-class and preparing for cabinet paper and all that. And then guess what happened? Several years later, that item in red, can you see that? In May 2007, the Bar Council expressed concern. That's it. That was my vision. In Working Group 10, everyone in the construction industry pays the appropriate amount by 2015. 2015, which was what? We're looking at 2003, about 10 years time, right? So give me 10 years. 10 years for the Act to be enforced and achieve that vision. And my vision was to remove payment as one of the 10 priority areas by 2015. Folks, is payment still an issue in the construction industry? Yeah. Anyway, I moved on. I literally gave up. When the Bar Council everybody was fighting about, oh, no, we shouldn't have the Act at all. And then eventually there was compromise and all that. Anyway, I moved on. I've been in New Zealand now for 14 years, 2007 or so. We came here and I thought, never mind. Oh, let me show you this. I decided coming to New Zealand, well, why don't I just do a PhD instead? Instead of fighting with everyone the whole industry is supportive of adjudication. But, in the end, it became a little bit, well, people had different opinions and so on. So I decided, okay, I'm going to look at adjudication, comparing the Malaysian proposals and the UK Act, which I thought was pretty much the best model, really, following the the New Zealand Act, following pretty much the UK style as well. And I had this question, whether acquired income deficiency syndrome and adjudication, whether adjudication can solve the problems or whether, it's not really. And I even looked at the skills expected of adjudicators. And I thought there is no point having adjudication if the adjudicators were going to be lousy. So I looked at, okay, they should have technical expertise. They must have management because time is critical. Adjudication, time limited. They must have legal expertise, interpersonal, as well as just common sense, really. I call it good sense because common sense is not very common. So good sense, And anyway, I moved on and I did that. Okay, so that in a nutshell is a little bit of a history. And there are many, many documents which have been published. And if you want, I can also list all of them as references, including documents published by the CIDB, responding to the Bar Council's 40 dalil why we should not have adjudication in Malaysia. So there's a document which says 40 reasons why we should not have adjudication in Malaysia. And then the CIDB coordinated a response, which myself and Yang Arif Lim Chong Fong wrote that responses line by line. And that document is a publicly available document. I'm happy to share this once this is all over. We will send you all the links and so on, okay? So that was that. That's a bit of a history and summary. Okay, now I just want to carry on. The past 5 days, we've been looking at construction contracts. This particular contract, again, we've run through this. There is a clause, obviously, in it on a dispute resolution clause, and we'll look at it in a minute. And just to recap, that contract is a plain language contract, okay? And these are the guidelines for plain language guidelines, which I would hope that all construction contracts in the world would adopt because they make sense. They make good sense, okay? This and this. And that reference at the bottom is a paper published by the Society of Construction Law in UK in 2008, which I wrote, which talks about legislation and construction contracts being written in plain language. So there you go. And we talked about the contract structure, having some sort of a logical time, cost, quality structure. And that is the paper, the reference is there. If you're not a member of Society of Construction Law, if you're an academic or student, you can get student access. If you're not, how do you get access? Just send me an email. I can send you my copy anyway. Okay. Now, I just want to highlight yesterday when we talked about the contract, just now was the main contract, and here was a subcontract that I referred to. Again, you can Google it. By the way, the link to the CIDB has already created a link to this particular contract as well as the STCC. Okay, so there are links to both of it. You can download both of them free. Now, the reason why I thought I should share with you is this. Now, there's this thing called plagiarism. Plagiarism in the academic world is a big sin, you know, dosa besar, okay? That means you don't copy things and then reproduce something or whatever. It's a big sin in the academic world. However, when it comes to construction contracts, lawyers use forms and precedents all the time and then they modify it, right? Likewise, construction contracts. So it's not quite plagiarism. I mean, if you look at the AIAC contract, okay, and you compare it with the PAM 2018 contract, wow. Okay, is that familiar? Yeah, a lot of similarity, but it's okay. Lawyers do it all the time. It's not quite full plagiarism as such, but you use what they justify it by calling it forms and proceedings. Okay, but that's what goes on anyway. So to me, perhaps one way of looking at it is plagiarism is the greatest form of flattery. When I set an assignment to my students, right, draft a brand new contract, redraft the New Zealand standard contract into plain language, or compare contracts from Singapore, from Malaysia, from Australia, New Zealand, and UK, and then you know, critically review it. One of my students highlighted to me, "Oh, Naseem, have you seen this?" I said, "What's that?" "CIDB conditions of contract for minor works." I said, "Oh, Jimmy, this is a few years ago that I realized this. It's published in 2013. Then I realized CIDB? That's not the logo of the Malaysian CIDB. Then I realized, oh my goodness, this is the CIDB conditions of contract for minor works published by in Mauritius in year 2013. And then I looked at it inside, page by page by page by page, and I thought, wow, this looks familiar. Remember, this is the year 2013. Then I realized, yes, I know this chap anyway. A friend of mine from Mauritius, and I had suggested to him many years ago, hey, why don't you draft a plain language contract? You know, it'll be nice for Mauritius to have plain language. And I gave him a copy of it in Microsoft Word and so on. And then he never, and I really encouraged him to look at the drafting style and, you know, feel free to use it. And looks like they took it on board and drafted their own, but the one that I gave him was a subcontract, but they decided to do a main contract for minor works. And they picked up most of the provisions and reworded it. The only problem is this, and I've just sent them an email this morning to tell them, hey, look, all the little bits and changes that you did, many changes are in legalese. So I'm happy to work with them. I don't charge, just to tidy it up. You know, don't write in legalese. And then I also told them, we've now got a 2015 renovation contract, which is even better than this version, which has got sections A, B, and C. So if you want, I'm happy to work with you to modify yours so that it's nice and brilliant without all the legalese, bits and pieces creeping in. And because I do want this to be a worldwide phenomena, as a template, as a model. So it'll be nice to see a Mauritius STCC version, which is really plain language, not, you know, with bits and pieces of okay, so that's just a few words about the background of that contract and so on. Now, I just want to quickly cover smart contracts. I know I'll do the questions from yesterday as well, but I want to clear as much as possible so that I don't have to come back to this part. Okay. Now, the future is about smart contracts. What is a smart contract? A smart contract basically is a series of computer coding, really. And when you do computer coding, it's always black or white. There's no room for contract interpretation the way lawyers say, oh, on the one hand is this, on the other. No, no, no. Computers just accept or 0 or 1, 0 or 1. It's black or white. Okay. Whereas contracts have got plenty of gray, and that can create problem. Okay. Now the plain language style has potential to reduce the gray. You can't completely remove the gray, but you can reduce it. Okay. Now if you do reduce it, then the computer can pick it up. Example. The contractor must submit a program by the 30th of every month, let's say. Okay, who? The contractor. Okay, the computer understands. Contractor, yep, okay. Must, mandatory, submit a program. Oh, yep, I know it's a program, says the computer, it says the machine. By the 30th of every month. Okay, it's going to recognize the date. Easy. Contractor doesn't submit. The computer, using artificial intelligence, will generate a letter, not the contract administrator, not the architect, engineer, or whoever it is. The computer, the machine, will generate a letter if the contractor doesn't submit it by the 30th. So maybe the computer on the 31st will say, maybe, I don't know, you can adjust the timing anyway. After 3 days, the computer will say, dear Mr. Contractor, under clause 4.1, you are supposed to submit an updated program by the 30th of May, 30th of April. You have not done so. Please, send an updated version, whatever. So do you see what I mean by using artificial intelligence? So that's the capacity or the potential capability of smart construction contracts. A lot of things are computer generated. Now I'm going to give you another example, just very quickly, because this is quite an important one. We're looking at the future now, 2030. Now, the other thing that a computer could do, for instance, say termination. Remember, termination was very procedural yesterday. 7 days, give notice, and this, that, and the other. Now, so the computer will have the program in it. It'll have the updated program in it. It'll have the contract in it, plain language one. And it will have all the other information, the site, notes, minutes, everything. Now, let's say the contractor hasn't been proceeding with the works. And according to the program, the planned program and the actual, oh, there's a bit of a discrepancy. Again, computer will not human beings, the computer will automatically generate. Dear Mr. Contractor, under clause 7.2.1, you're supposed to have finished the substructure works by this date. You are now delayed by 7 days. Please speed up, failing which the client reserves the right to terminate your employment, for instance. Some sort of a letter like that. So that can be generated by the computer using artificial intelligence. I hope you understand now how what potential smart construction contracts have to create much greater efficiency in administering construction contracts. Okay, now, so my contention is this. Plain language construction contracts are a precursor to developing effective smart contracts. You can create any kind of smart contract you want, but if you want a brilliant smart contract, a really intelligent one, a plain language contract is a precursor. In other words, prerequisite. In other words, you must use plain language contracts in order to develop smart contracts, because the person who's doing the code is going to struggle with a very long sentence and so on. Now I've also cracked the E equals MC squared formula. This took this is definitely more than a year. Yeah, it took me more than a year. I think it might have been, I think I was talking about this maybe 2 years, 2.5 years ago or something. I was trying to look at E equals MC squared, and I kept getting it wrong because I thought, oh, the efficiency of a contract is directly related to the M, the mass, the number of words. Oh, but it's not. It's 1 over M. Damn. So I couldn't quite get it. So in the end, I finally cracked the code of E equals MC squared. That is, E, not for efficiency, E is the possibility of error. The number of errors is directly proportionate to the number of words and the complexity of the words used squared. There you go. E equals MC squared. Thank you, Einstein. I hope it's not copyright reserved. Anyway, formulas cannot be copyrighted. So there you go. That's my formula for plain language. Okay, I've purposely put this clause here because it demonstrates how artificial intelligence is going to pick this up, how the person who is coding it as a smart contract is going to pick it up, and how the computer is not going to work. This is not going to work. For instance, if a dispute arises between the parties under or out of or in connection with this subcontract, that's okay. Or under or out of or in connection with the subcontract works. I think that's not too bad. The computer will know subcontract works. Well, doesn't matter. It'll just ignore it. Okay. The parties shall endeavor. Aha. The computer says shall means mandatory. Then the computer says, okay. So that's mandatory. Parties shall endeavor. But it says shall endeavor. Shall endeavor to resolve the dispute through negotiation. So the computer is thinking, so is negotiation mandatory or not? Because they need to establish that before warning or terminating the contractor, okay? Or triggering the next dispute resolution method like mediation or arbitration or whatever. So the computer is saying, but shall means must. But here, shall, does it mean must or not? Because it says here, shall endeavor to resolve. Never mind. So the computer is a bit stuck, but let's carry on. If negotiations fail, the parties shall refer the dispute to mediation. Okay. So if negotiations fail, then parties refer to mediation. So the computer is thinking, yeah. So negotiation is a prasyarat, precondition, precursor, if you want. So you must have negotiation and then only mediation. So the computer is saying, all right, okay, fine. And according to Singapore mediation rules or whatever. And then it says here, for the avoidance of doubt, prior reference to dispute of the dispute to mediation shall not be a condition precedent for its reference to arbitration. Hang on. Earlier it said the parties shall refer the dispute mediation. So in other words, okay, so mediation is not mandatory. Look, it's all a mess. Anyway, let's move on. I hope I've presented my point clearly. Now, the entire construction contract can be presented as a flowchart. This comes from the NEC series of contracts, okay? Now, the NEC clauses have been, developed in a flowchart manner. And there's just one clause, okay? So again, these are things that can facilitate the computer reading and making decisions. Yes, no, yes, no. But the words in there have got to be clear. Okay. Now, I want to talk about the reforms first, and then I'll go to the clause and the questions from yesterday, okay? Now, so among the reforms are to enhance contract administration, to make it more effective and more efficient. Efficient means it's quicker, cheaper, okay? And effective means less prone to errors, okay? So if we have self-administered smart contracts, that will all help. And then, of course, there's also when you're administering contracts, you have the protocols. How do you decide whether to get extension of time or not? There's all kinds of principles. I didn't even deal with this. It's too much. Dotting on principles, the net method, the gross method, and so on. But that's can never be done within just a day or so. Okay. There are other reforms that can be looked at. For instance, adjudication legislation. I already talked about that. Legislation should be in plain language. Legislation should have a common set of drafting guidelines so that they're all consistent. And ideally, legislation around the world should use common terminology. Let me demonstrate an example. The whole world, when it comes to arbitration, they call it arbitrator, they call it arbitrators award. The whole world, more than 100 countries. Arbitrators award, arbitrators award. Malaysia, Singapore, Hong Kong, New Zealand, UK, everywhere. Okay, more than 100 countries. They say arbitrators award. But when it comes to adjudication, oh God. UK calls it decision. And then New South Wales came up and called it determination. Why? Because they said, oh, no, it's only to determine, it's more like a certification, it's only for payment. Okay, whereas in UK, it's a dispute resolution method for everything. So they said, no, we must call it a determination, just to determine how much to pay and so on. Okay, then Victoria used determination. And then New Zealand looked at it and said, well, although we're using the UK model and we are going to determine both the quantum, payment, as well as other disputes, but for some reason, they use the word determination. That's the one annoying thing within the New Zealand Act, which the parliamentary drafters did not take heed of. Maybe they didn't look at the UK Act at that time. They were looking more at the Australian one and all that, and they were influenced by that. Anyway, Singapore used determination. The other 8 jurisdictions in Australia all use determination. Oh, no, not all of them. I think Queensland used decisions, and maybe Northern Territory. Brilliant, use decision. And in Malaysia, I persuaded young Arif Lim Chong Fong, or Lim Chong Fong as he was then, as a lawyer. I said, we should use decision, because decision is what it is, you know, and you can use determination as well. But determination has got 3, determination, 5 syllables. Decision is 3 syllables. It's better. First reason. Second reason, determination has got many other meanings. It can mean terminate. It can mean to end the contract. You know, or it can mean I'm determined to finish this by 8:05, for instance, you know, and determination is also a decision. So I say use decision, and he actually did. Now, in the original model, we also had an appeal process copying the Singapore appeal for adjudication process with 3 adjudicators. Initially it was there, but eventually, as I said, you know, the lawyers were saying no need and all that's just whatever. Anyway, so there isn't. So we distinguished it. Decision, and then determination on the appeal centers. But anyway, that didn't happen. Fine, life goes on. Now, the other thing about reforms is adjudication has been working so well in so many jurisdictions. So is there a possibility of adjudication being exported to other non-construction industries? Sir Vivian Ramsay has said that in the UK. In my research, when I was doing my PhD, when I was based in Dunedin, I was thinking the same thing as well. And I spoke to a law professor in Dunedin, but they're not really into dispute resolution or construction. So anyway, I say, yeah, why not? But it didn't really take off. And that's that. We left it as that. But why not? Of course, e-arbitration, e-mediation, e-adjudication, I'll share with you a few things. And a specialist court. UK has got it. Malaysia has got it. Wow. That's one thing which the Bar Council, adjudicators, the Adjudication Society in Malaysia, Society of Construction Law, the construction industry, CIDB, everybody was unanimous. Yes, it is a good idea to have a specialist construction court in Malaysia. That's the one thing that everybody agreed. And then there's other things, construction law report, which I'll mention. And when it comes to other reforms, like bridging the academic and industry gap, I really think that there must be greater bridging of the gap between academia and industry, rather than each one, well, in their own way. And the other thing is undergraduate level. Where is it? There doesn't seem to be enough emphasis on the area of construction law, construction contracts. Seriously, I have looked at the syllabus of degrees in many countries, including New Zealand and Malaysia. Not so much Malaysia now, I've left that, but I've looked at the syllabuses in other countries, including New Zealand. You look at the degree, even from top-ranked universities around, worldwide, University of Auckland, the architecture degree doesn't have much on construction law, construction contracts. Nor do even civil engineering program, a little bit better, but nowhere near as much as necessary. In India, massive shortage. I was there in December, and they were saying the same thing. And the president of the New Zealand Institute of the equivalent, the Indian Institute of Quantity Surveyors was moaning about that as well. So there's not enough undergraduate. Now, at postgraduate, it's even less. Now, this is a quote from the president of the Indian Institute of Quantity Surveyors, who said, undergraduate Indian engineering degrees doesn't adequately cover contract procedures, procurement, construction, or dispute resolution. Then there's a huge gap that's been missing that needs to be plugged. Okay. This is what he said. And so to me, that is one sort of a shortfall, and we need to address that quite seriously. Okay. Now that is from the strictly academic side, and I'll talk about postgraduate programs in a minute. Meanwhile, for the people who are in industry, who are not doing a structured program, who already got the degree and so on, continuing professional development should be mandatory. I think there's no question about it. I think the world over, all construction professionals have it anyway, okay? Because one of the requirements of a professional is understanding the concept of professionalism, including putting the client's interest before self-interest. So those concepts will be picked up when you do continuing professional development. And now what I want to do is, I want to demonstrate what happens if you do continuously pick up skills in, here is my example, redrafting, which one of my students did. Okay, so there you go. A program clause on the left and a program clause on the right. This is from Nico Lambert, okay? And he did a survey of it. And he asked the users, which one do you prefer and all that? He got consistently similar results to what's been happening around the world. Over 80%, typically, 70, 80%, more than that, prefer the plain language one. And observe right at the bottom, word count, 125. Originally, 290. Wow, it's nearly half. Okay, and maximum words per sentence 29, on the other one is 44. And of course, amongst the research, this was done at University of Auckland. One of my master's students there had, in the assignment, he had demonstrated how multiple crisscross referencing in the dispute resolution clause in the New Zealand Standard Contract NZS 3910 was causing confusion, because that was his assignment, and he demonstrated that. And of course, you know, words like a recorded delivery, for instance. I mentioned it in one of my earlier series, so I don't want to cover that again. But the word recorded delivery existed in the architect's contract and even the government contract in Malaysia for all these years, copied from the UK, but it doesn't mean the same thing as hand delivery, so on. Okay, and of course, when quantity surveyors especially, you know, start fiddling around with the preliminary section, they say works must be constructed strictly in accordance with the drawings. And then when the contractor starts following strictly and starts putting in the A610 on the staircase as well, then you complain, oh, you know, I don't mean that, you know, I meant the drawing details and so on. And then architects tend to put clouding, you know, to show this is where it is and all that. And contractors follow strictly in accordance with drawing. And then you complain saying, oh, what is that? You know, that's not a hole, it's just a bit of a clouding. Now, I will show you in a short while, one of the clauses from AIAC. Now, AIAC 2019 Design and Build Contract is brand new. By the way, again, a reference for anyone who is outside New Zealand, outside Malaysia, who wants to download this contract. AIAC is the Asian International Arbitration Center. They have a series of contracts with bills of quantities, a design and build version, a small projects version, and so on. I have been told by them during a Royal Institution Surveyors meeting where I joined in through Skype, you can download, you can freely edit it, copyright, you won't be in breach of copyright. So feel free to download it, fiddle around with it, and use it as you wish in your own jurisdiction, your own country or whatever. The problem is this, it's not in English. Well, it is in English, but it's in traditional legalese. Okay, so what I've done is I have attempted to redraft one of the clauses, which originally was about 1,700, 1,900 words. My redraft is about 1,300. It's still too long, but I've attempted to redraft. I'm happy to share it with you. If I can, when I look at the other slides, I'll show it to you. Anyway, otherwise we can just email to you. Before and after, I think about 23% reduction. And I'm pretty certain, and I will be sending this to AIAC at some point. Can you please confirm that the original and the redraft are fine? Okay. And then, of course, academics can keep busy as well when it comes to disputes. So they come up with articles like disputing the existence of a dispute as a strategy for avoiding construction disputes, you know, for instance. So everybody's busy. Okay. Now, the other thing I want to briefly mention for the future, right? We're talking about reforms now. Even consultancy contracts should be rewritten in plain language. I mentioned in an earlier series, but I'll mention it today in case some of you haven't attended this before.
It's 7:45.
The New Zealand Institute of Quantity Surveyors consultancy contract is the first to be accredited as a clear English standard by the Plain Language Commission UK. There's a resource there. I think only members can download. So if you need a copy, you can always write to Marilyn, who is the NZIQS executive director. You know, if she's kind, she might, you know, send you a copy over there. This is the cover page, how it looks like. And as I said, it's got that clear English standard accreditation. And guess what? Guess who? Well, I set an assignment for my master's students at Massey University in construction law. And they said, and I said, oh, redraft the current NZIQS consultancy contract, the two versions, short and long one. And one of them came up with such a good piece of work, actually two of them. David Finney, who is since finished his PhD, is waiting for his examination. And Nico Lambert, who has finished his master's, just waiting to convince his girlfriend or wife or whatever, why he should do a PhD. Maybe we'll organize some scholarship for him or whatever. He's brilliant. So what we did was took that, refined it and all that, and then sent it to a bunch of prominent quantity surveyors in New Zealand, former presidents and fellows and so on, and 3 lawyers who looked at it from Kensington, so on, reflective construction law and so on. Ari, who is in this panel of the Society of Construction Law Council and so on, and they gave the okay. Yep, it was all good. So there you go. So by 2030, all consultancy contracts in the world should be in plain language. We've done it in New Zealand. So hey, look, feel free to copy it. And it's a fillable PDF. So it's not a smart contract, but it is a if you want, electronic version of a contract where you can fill in the blanks. This is another example of what, again, this was Nico Lambert again. Another assignment. I said, hey, look, when it comes to extension of time, all that. Oh, no, sorry, this wasn't an assignment. This was his research project, okay, where he looked at extension of time. He downloaded the UK one, 70, 80 pages, 79 pages, okay? And wow, of course, by now, he knows the benefits of plain language. So he decided, let me come up with a New Zealand version of it. And it was a mere, I think it was about 23 pages or so. Wow. Now, this hasn't been publicly shared yet, but at some point I would like to work with him, refine it, and talk to the Society of Construction Law in New Zealand or maybe anywhere else and see if we can have a plain language version, just a mere 20 odd pages rather than a heavy 79 page version. And this is the contents of it, the contents of that protocol. Yeah, 23 pages. There you go, nice and simple, written in plain language, of course. And I mentioned about adjudication legislation. I mentioned adjudication beyond. I want to mention briefly about e-ADR, not just adjudication, but e-mediation, e-arbitration, and so on. If it is documents only, e-ADR becomes very attractive. If it is, if it requires you to have well, hearings or meetings or whatever, well, it can still be, we can still adopt e-ADR. Example, this Zoom session, for instance. We've had hundreds of people logging in. So why can't you have multi-party hearing? Why not? Okay, so it's possible. And the benefit is when you have e-ADR, you send through a document, it's contemporaneous, immediately instant communication to everyone. So you won't fall foul of what breach of natural justice. Oh, you spoke to one party without talking to me. That won't happen. Okay. Issues could be size of storage data, which is a minor point, and issues of security and all that. You can always password protect. You can just get some computer WizKids to enhance the security features, and you can even make sure that there is evidence to show unique IP address. At Massey University, my students log in, okay, for their assignments and everything else, and discussion forum and all that, and I can see where the students have logged in from with a unique IP address. For instance, this is an actual screenshot of one of my students who had logged in from 115.188.128.79. And that was, as the image shows, Auckland. One of my students said, oh, I'm overseas now and in a remote area, I can't get regular internet access. And I checked on him. Yep, he was somewhere in Jakarta, okay? And 2 different times he was in, you can see the different addresses and so on, right? And good, verified. So he's telling the truth, whole truth, nothing but the truth. Well, good stuff. So yeah, I excused him, okay? Now I mentioned about the Specialist Construction Court. In UK, more than nearly 150 years. In Malaysia now, we've got 2 specialist courts. The question is, should other countries follow? I have been talking to some people in New Zealand. They said, well, we don't have enough cases. That's just an excuse. Because the technology construction court, you know, or just a construction court, doesn't mean they only do construction case. They can do commercial cases as well. Just allocate one to start off with. If they don't have enough cases, just leave it as one court. But they'll be doing other work as well. And if work picks up, then have another one. I think in Malaysia, we've got 2. There's discussions whether there should be a 3rd because they're busy now. Now, the other thing, again, we must appreciate things which I know people sometimes complain about CIDB, saying, oh, CIDB, you know, take a lot of money, 0.25% of every construction project in Malaysia, you know, they have a lot of money. What are they doing? Well, this is one of the initiatives. construction law reports are very useful, but often it is only read by lawyers and judges and so on. So why can't we in industry read it as well? So CIDB came up with a series of construction law reports and commentaries from laypersons and so on. So here's some of it. And there's a summary of the case, for instance, and then there's a commentary. This one, for instance, is a published document, so I'm not worried about comments or whatever. But you can see the style of commentary on the right-hand side here. Commentary for lawyers, further consideration should perhaps be made as to which points to pursue in submissions. Construction people might not even know what you mean by submissions, pursue in submissions, but that's the way lawyers write. So what CIDB decided was, hey, we should also have a commentary from construction professionals. So there you go. This one, for instance, commentary from a construction professional, a non-lawyer. I'm not a lawyer, by the way. There are several lessons that may be learned from this case. When payment is due, parties should pay up. Payment here refers to payment under a construction contract, which includes both construction work contracts and construction consultancy contracts. That, by the way, you can see from on the left here is a public document, was my commentary on a particular case. So there you go, different stuff. Okay, I want to touch on educational reforms again. I want to highlight this. Now, not everyone seems to have heard about this, but I just want to highlight its awareness. Again, the link will be there. You can download this. One of our Court of Appeal judges, Dr. Hamid Sultan, has suggested that, hey, you bunch of academics, what are you doing anyway? You're intellectuals. We're so busy in court and we don't want to have courts and then have appeals and then going to federal court or Supreme Court or whatever it is, right? We don't want that. So why don't we, for technical cases, pass it to you and you conduct it as a court-annexed arbitration? And there's a whole proposal in that brilliant document. It is not just for Malaysia. It is, he has told me, he gave me 5 copies and he said to give it to the Chief Justice of different jurisdictions. So if any of you has come from different countries and you've got access to the Chief Justice, can I please ask you, I'm having to give you a hard copy of it, please pass it to your Chief Justice of your country. Perhaps if anyone is from Mauritius, you could as well. I'll be happy to give you a copy, or from Australia, New Zealand, and so on. I'm not a lawyer, so I'm not normally mingling with Chief Justices and so on. So it's a good proposal, and you can download it free as well anyway to see what he's suggesting. I mentioned about bridging the academic and industry gap. Yes. Now, universities educate people. Polytechnics or diploma or certificates, they teach you to be skilled. Training is done in the workplace. Monkeys need to be trained, but universities don't train people. Universities educate them to think, come up with ideas. They do research and so on. So they don't need, well, there's a little bit of training as well, how to climb a tree. No, sorry, not how to climb a tree. Well, how to administer contracts, for instance. Oh yeah, the clause says within 7 days, so you do it within 7 days, But overall, the process is educating people. That's my experience when I did my master's in construction law and arbitration in King's College. And that is the approach that I've taken at Massey University. Students need to develop thinking skills. Okay, we're not monkeys. We don't educate monkeys, we train monkeys. Undergraduate, I mentioned that. I mentioned continuing CPD. Now, I just want to mention one thing about mandatory CPD. I fell off my electric bike on June 22nd last year. So it's not quite, I mean, one side is 90 degrees, the other side is, I'm getting about 45 or so degrees, up to about 50 degrees after a bit of warm up. Fell off the bike. And I was just thinking, wow, if my surgeon hasn't done his CPD, or if CPD is not, continuing professional development is not mandatory, I hope he knows what a CT scan is. Anyway, the point here is CPD should not be debated about whether it should be mandatory or not. It should be mandatory. Okay, mandatory CPD or not, that should not be a question. And please, for those of you who are here only for one reason, you want CPD points from the RISM, that's why you're signing your name and then you print out so that I get 1 hour of CPD points or 5 hours this week or whatever. That's not why you're here. You're here for good knowledge. But anyway, if you happen to get a CPD, that's fine. Okay. Now, I mentioned about the specialist program in construction law, and now, trillions of worth of projects, all of them have got a construction contract. And yet there are only about 13 or 14 master's program specialized in construction law in the world. Did you know that? 7 in the UK, including the King's College one, which I studied there. And I developed the one in Leeds in 1992 December. And guess what? Up to now, and then the Malaysian one, I was an advisor to the UTM, University of Technology Malaysia, master in construction, in contract management. And I was made an associate professor quite a few years ago when I was in Malaysia. And then, of course, the Massey University one, which developed in 2014. And that's the 13th such master's program. And potentially, of course, there's one in Middle East, Hong Kong, Australia, and Sri Lanka. But that's not enough. At the moment, we're in discussion with a university in Malaysia to offer the Massey University program jointly with a university in Malaysia, so that at the end of the degree, if you do it in Malaysia, you get 2 pieces of paper. One, a Massey University Master of Construction Construction Law, and one more from the university in Malaysia, Master of Construction Construction Law. So you get 2 pieces of paper for the price of one. And you're working on it. I hope it happens. Hopefully, by August next year. If not, then 2022 February is when it's going to start. Okay, and I mentioned some of the outputs done by my students, and here are some of them. I already showed you the delay guidelines. Some of them come up with esoteric topics like not a theory of everything, but a step to unified theory of variation, waiver, and estoppel. Oh God, Andy, you gave us a hard time, but never mind. It's good. It's good. He's a Toastmaster as well. He enjoys that. Murray Kerr's work was really good as well. He looked at in a New Zealand context, analysis of the modifications done and so on. David Finney's PhD, he came up with a pre-construction services agreement itself, okay, for 2-stage early contract involvement. Wow, amazing. A draft anyway at the moment. It's not formally published. I mentioned the NZIQS consultancy contract. And I've showed this slide every day throughout this week, but I'm reminding you, okay, legal services need to be, lawyers, clients will refuse to pay. And I also reminded you about smart contracts, the importance of it, okay? Rascals exist, yeah? But you just have to just get up and keep going. So there's nothing wrong in going down. Sometimes people will slap you or punch you or whatever. But staying down is where it's wrong. Some people take the attitude, well, I'm not bothered and so on. But the question is, are you going to continuously improve something or not? My point here is, life is not just, well, life just carries on or whatever. To me, you should look at life as a series of continuous progression towards something better. So that's the target anyway. Okay, now what I'm going to do is I'm going to quickly share with you the clause from the dispute resolution clause in the contract which I mentioned yesterday, and I'll just make it slightly bigger. Okay, right. Now, the dispute resolution clause really is no big deal. The clause on negotiation and mediation is just voluntary. There is no clause on adjudication because you don't need to. It's a statutory enactment provision. And the arbitration clause is boring. It's the same old, same old. All disputes refer to arbitration. The only difference between this arbitration clause and any other typical contract is, guess what? It's written in plain language. It's only a page and a little bit. That's all. So there's nothing magical about the arbitration clause at all. If you were to compare this arbitration clause with the arbitration clause in the PAM contract or JKR contract and all that, it's pretty much similar. The approach is only when you have finished the work, you can refer the dispute to arbitration. Okay, right. Now I'm going to share with you one other document, if you can bear with me just for a short while, and that is the it's the questions from yesterday. I'm going to quickly run through questions from yesterday and share with you that document, because I did say I will deal with every question that you have posed, and I do intend to do that, and we will do that now. Okay, so what were the questions? Hello from Rwanda. Hello again. Only reason I put that is because, it's nice to see someone even from Africa logging in. And of course, there's one chap who is doing a bit of research, so you can download the survey and so on. Tech Moderator has been putting in the various YouTube links. So we keep getting this question. Obviously, some of you are new to this. The answer is all these sessions will be put up in a YouTube channel where you will have everyday session on a YouTube, not now, next week, or whenever it is that Daniel and his team have got time to put it all together. Okay, so have some patience and we'll give you all that. So don't worry about it if you've missed it and so on. Let's deal with the technical questions. Is there an order of priority provision under the STCC contract to deal with discrepancies? The answer is there isn't. You can have an order of priority. Drawings prevail over conditions and so on. So because there isn't an order, common law principles will apply. In other words, written words will prevail over printed conditions. For instance, if you put something in the bills of quantities, that will prevail, or drawings, over a printed standard terms of contract. Question: if a lump sum contract has some general arrangement drawings, and later stage drawings are included and alterations is not evident yet, what will impact? Oh, okay, yeah. If you've got discrepancies, assuming it's in conflict, then you have to refer to the contract administrator for a determination. Look, this or that. But if there is no conflict, they are to be read as mutually explanatory of one another. Okay, right. Next one. Since there are possibilities of contract documents not being bound even until the end of the contract, do you think SIPA should be amended to include oral contract? The answer is yes, absolutely. The original proposal that we put forward, Chong Fong and I and the industry supported it, was oral contracts included, like Australia, all the 8 jurisdictions, Queensland, everywhere, like in New Zealand, like the amended version of the Act in UK, oral contracts are included. And suddenly Malaysia excludes oral contracts. I tell you what, I'm willing to bet that, well, no, I won't bet this, but I'll just say, I think in future amendments, oral contracts will be included in Malaysia. I tell you why. Earlier, lawyers were worried about adjudication, but now they've embraced it wholeheartedly. They love it because there's plenty of work. That being the case, the chances are they wouldn't mind oral contracts being included. Earlier, they were trying to suppress it. Now, oral contracts, why not? Absolutely. Because a lot of questions, which a lot of contracts are entered into orally. Now, it's not because the contract is bound until later. Remember, the contract is already formed. You don't need oral contracts because there is a contract in writing, even if it is not bound. So don't worry about it. If loss and expense, a loss of profit is being cancelled when the contract is being formed, can the contractor still argue for loss of profit when decides to part of his work to another NSC is being cancelled or this form? Okay, the answer is you can always omit work. There's no problem. But what you can't do is omit and give it to someone else during the currency of the project. That you can't. Then you can get loss of profit and sue for damages. In a lump sum contract, SOL investigation report is included in contract documents. Actual SOL can be different. Our contract mentioned the contract deemed to have made himself is eligible. Okay, now here is a problem, isn't it? At tender stage, you are telling the contractor, hey, Mr. Contractor, you're supposed to do all the investigation. My word, how is the contractor going to do it? I'm sorry, if the contract is crystal clear, you have to do your own SOL investigation and you have got access to the site and so on, then I'm afraid, tough, you really do have to do. This is where I think clients should play a role. Why do you want every contractor who is tendering to do their own SOL investigation? Why not get them all a single set of SOL investigation report done by an engineer and give it to them? You know, just makes sense. Reference to SCC, how and when advance payment is to be recouped. Is there any applicable formula? No, there is no formula. It's a nice, simple recoupment. If you look at the pro forma template in the payment template, it will say deduct advance payment, for instance. So in other words, you recoup it very fast without a staggered formula. If there's any damage caused by a driver for machine that's used in the construction project which doesn't have insurance, driver pay is very less. That means the driver is underpaid. When compared to cost machine, then who should bear the expenses? Not bear, B-E-A-R, right? Bear the expenses. The answer is, well, look, there's a possibility that as an organization, a company, a contractor, whatever, you've got your employee, poor employee, and there's no insurance and so on. And you are the one who has told him, drive this and the machinery and all that. There's a possibility under the concept called vicarious liability. That means the employer is liable on behalf of the contractor. So that's a possibility. Okay, some country specialists invited, selected, eventually became domesticated under the domestic, not through NSC. It's not fair practice, but it becomes a norm. Absolutely, yeah, you're right. It is possible, but hey, look, make sure you price for that risk. Juwita said, I'm listening. Oh yeah, this was a challenge to Juwita to redraft the PAM contract. And guess what? Last night, I redrafted 2 clauses and actually shared with her. I can share with you as well, but we were running out of time, so I don't want to go beyond 8:15. I know we had a float of about 15 minutes or so, but I don't go too far beyond. So for proprietary system, example curtain walling involves shop drawings submitted by specialist contractor. Does that include responsibility for fitness purpose? Under the PAM 2018 contract, when I read that yesterday, if the contractor designs anything, including his subbies or whatever, is a contractor, the answer is yes, fitness for purpose for everything. In other words, absolute guarantee. Yes, absolutely. That is what it says. However, if it's the architect who designs it under the consultancy contract, it is reasonable skill and care. And if you don't know what I'm talking about because you missed yesterday's session, then you should come and do a master's. No, you shouldn't. You should listen to yesterday's recording. Anyway, as an architect, I would like to offer myself to join you to draft the PAM contract plan. Brilliant. I've been in touch with this chap. Thank you very much, sir. I really appreciate it because it's nice to have an architect as part of the feedback. You know, we want to bounce off ideas. The more architects, the better, because you are the ones who are administering it in Malaysia anyway. And I just said that, and someone said, very confusing. An architect doesn't even understand it thoroughly. How do we expect contractors to read and understand their role and all that? Yeah. Okay. Now, what I can do now is I can share with you one other document if you want, or I can go straight and finish it off. But I'll just share this very briefly so that you know what has been happening. Right, I mentioned about the AIAC, designable contract, right? This is one clause from the AIAC contract that I have redrafted. If you look at on the left, the requirements for a preparation, submittal, updating, revision of the contract are set out in this clause of requirement. On the right, you see, this clause sets out the provisions. Can you see the style, the numbering? I tell you, everything is captured on the right-hand side, which is a redraft. And if you look at, again, another example here. Should the contractor fail and or neglect to, whatever, on the right it says, if the contractor, 1, doesn't submit, 2, does not upgrade, and so on. That's a style, nice and easy. And if you look at the very last item, 1,737 words in the original, 1,327 in the second round, in the first redraft. After the first round of redraft, 23.6% shorter. That is how powerful a redraft could end up with, okay? Now, I will go back to the very last slides, and right towards the end, I just want to share with you, by the way, smiling because I'm going to finish shortly. And the reason why I thought I should have this slide is for 2 reasons. One is to remind you about Vision 2030, all construction contracts will be rewritten in plain language. And the second thing is, I want to just an appreciation again to a number of people who have given me direction and helped me along my way. Organizations like CIDB and CIBE and RISM and so on and so forth. Okay, yeah. But as far as individuals are concerned, my very first job in Malaysia as a fresh graduate from Reading University in 1986 was Basa and Harun. They gave me an opportunity. Okay. And then later on, I went to the UK. I worked in Leeds. I was working in industry, and then there was a recession. I worked in Leeds Beckett University, where I developed the master's in construction law. Barbara College gave me an opportunity. And then Robert Ellis was there, but then he passed away. And then later on, I went back to Malaysia. John Fisher was my mentor when I picked up skills in project management. Project management at that time, okay, 1993, 94, 95, and so on. And then I set up a quantity surveying practice, okay, and I had some colleagues and so on. I thank you all. I can't mention everyone. And then later on, what happened? Yep, I'm in New Zealand now. I decided to join the academia. Professor Ian Maddox gave me an opportunity. So did Professor Robin Phipps. I didn't have a PhD then. but they gave me an opportunity because of my industry experience. I had a couple of masters, 2 masters, but you know, normally the academic line, they want you to have a PhD. Anyway, eventually I did finish my PhD under supervision of Professor Suzanne Wilkinson, who is also my colleague now at university. And then of course, right now I've got my own boss who's been extremely supportive, Professor Monty Sutrisna. Now, to one of you who sent a message, say hi to Monty. I did say hi to Monty. Apparently you are in Curtin, if I remember correctly. You are his former student and so on. And yeah, so Monty says hi as well. So, I can't name them all individually. Puan Saria Norinazes, Z, who is probably listening in, Amina, of experts, including, of course, our tech moderator, Daniel, when he puts on his Superman glasses, he really does look like Superman, and he's got a good choice of taste and so on. Now, we can all see Vision 23, what it is, and we can all see clearly now what it is that plain language construction contracts are about and what our vision is. There's a slideshow now that is going to be played by the tech moderator, but before he does that, I want you to observe a few things. All this was taken in New Zealand, and most of the slides were taken literally during the lockdown period when we used to walk in our neighborhood. I just want you to appreciate how, if any country keeps itself clean and green and environmentally friendly, we will all benefit, okay? Now, I want you to observe things like a peacock, a swimming pool, which is empty at the moment, which I used to swim every day, and I will, cows, a cat on my fence, a hedgehog walking along the streets because of lockdown, a construction site, me with my e-bike, more cows, cupcakes my daughter made, sheep, and finally the beach. And the last picture is a picture of the rainbow at the beach, which is about 6 minutes drive from my house. Now, the point here is we have beauty within the grass is not greener on the other side. The grass is green where you water it. So whichever country, I know there are people from 18 or 19 countries who have registered for this. So even if you're not watching this right now, whichever country you're watching this from, water your own grass and you will find the grass becomes greener in your own backyard. So it's not just about New Zealand. And I just want to share with you how lucky I am to be here to experience this during a lockdown period. Most of the slides were during the walks that we've had. Some of them were in a little bit further out, okay? So tech moderator, over to you. Thank you very much, all of you. There may be future sessions at some point, but as long as you've registered and your name is in the system, they will send you details of slide things and future events and so on. I'm now going to stop sharing this, and the tech moderator will share you. It's a 3-minute video. So just listen to this. Thank you all.
It's been a long day without you, my friend, and I'll tell you all about it when I see you again. We've come a long way from where we began. Oh, I'll tell you all about it when I see you again. When I see you again.
Damn, who knew? All the planes we flew, good things we've been through, that I'll be standing right here talking to you about another path. I know we love to hit the road and laugh, but something told me that it wouldn't last. Had to switch up, look at things different, see the bigger picture. Those were the days, hard work forever pays. Now I see you in a better place. How can we not talk about family when family's all that we got? Everything I went through, you were standing there by my side, and now you gon' be with me for the last ride.
It's been a long day without you, my friend, and I'll tell you all about it when I see you again. We've come a long way, from where we began.
You know we started.
Oh, I'll tell you all about it when I see
first you both go out your way, and the vibe is feeling strong. And what's small turn to a friendship turn to a bond, and that bond will never be broken, the love will never get lost. And when brotherhood come first, then the line will never be crossed. Established it on our own when that line had to be drawn, and that line is what we reach, so remember me when I'm gone. How can we not talk about family when family's all that we got? Everything I went through, you were standing there by my side, and now you gon' be with me for the last ride.
Let the light guide your way. Yeah. Hold every memory as you go, and every road you take will always lead you home. Oh, it's been a long day without you, my friend, and I'll tell you all about it when I see you again. We've come a long way from where we began. Oh, I'll tell